Me to our news channel. Let's talk about hot topic today about day 2 of jury deliberations in Trump criminal trial. The jury has now deliberated for over 11 hours in the criminal trial of former President Donald Trump. This case involves 30 for felony charges of falsifying business records connected to a hush money payment to an adult film star before the 2016 presidential election. The 12 New York jurors who surrendered their phones for the deliberations can only discuss the case when all members are together at the Manhattan courthouse. They must reach a unanimous decision on each count, determining whether Trump committed the crime personally, acted in concert with others, or both. Former President Trump has claimed that Judge Juan Merchan is not requiring a unanimous decision on the charges against him. In a social media post, Trump described Merchan's supposed stance as ridiculous, unconstitutional, and un-American. This claim echoed conservative assertions, following a post by Fox News anchor John Roberts, which suggested that Merchan had told the jury unanimity was not required for a conviction. Facts first. Trump's claim inaccurately reflects what Merchan said. Judge Merchan instructed the jury that their verdict must be unanimous on each of the 30 for counts. To convict Trump of felony falsification of business records, the jurors must unanimously agree that he falsified business records with the intent to commit, aid, or conceal another crime, specifically a violation of New York election law. Merchan clarified that while the New York election law prohibits using unlawful means to promote a candidate's election, jurors do not have to agree on which specific unlawful means Trump used. They can find him guilty if they unanimously agree he used some unlawful means. Prosecutors presented 3 theories of what unlawful means Trump employed. Merchan explained to the jury, in determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following. 1. Violations of the Federal Election Campaign Act (FECA). 2. The falsification of other business records. Or 3. Violation of tax laws. After closing arguments on Tuesday, Trump posted on social media, repeating his misleading claim that Judge Merchan has prevented him from employing a certain defense in the trial. Trump stated, "The greatest case I've ever seen for reliance on counsel, and Judge Merchan will not, for whatever reason, let me use that as a defense in this rigged trial." Another term, advice of counsel defense. He reiterated this point on Wednesday morning. Facts first. Trump's claim is misleading. He did not mention that Merchan barred his legal team from invoking the advice of counsel defense because Trump's lawyers had previously informed Merchan that they would not use this defense. An advice of counsel defense typically requires the defendant to waive attorney-client privilege. Trump's lawyers had proposed an alternative approach, intending to highlight the involvement and advice of lawyers without waiving privilege, which Merchan rejected in March. Merchan explained, to allow said defense in this matter would effectively permit defendant to invoke the very defense he has declared he will not rely upon, without the concomitant obligations that come with it. The result would undoubtedly be to confuse and mislead the jury. This court cannot endorse such a tactic. Thank you for watching.